So the topic we are going to discuss is about the president. So the constitution, how defines the president. So article 52 to 78 in part 4 of the constitution has deal with the union executive. So the union executive, so who are in the union executive? The union executive consists of president, vice president, prime minister, council of minister, and the attorney general of India. So president is the head of the Indian state, and he is the first citizens of India, as we know that. So he is the symbol of unity, integrity, and solidarity of a nation or a country. Like anything done, like law or anything which which is done on the name of president. So now we'll discuss about the election of president. So election of president is given under article 54. So how we so the president is elected not directly by the people but by the member of electoral college. So there is a two kind of election, that is direct election and indirect election. So direct election means where people means the citizens of a nation directly chooses the representatives through a universal adult franchise, or whereas indirect method is where indirectly chosen the representative like the president or like the vice president. So now we'll see the how president is elected. The president is, so there has been something criteria to elect president. The first criteria should be he should be the elected member of both the houses of parliament, or the elected member of legislative assemblies of the state, and the elected members of the legislative assemblies of the union and Delhi and Puducherry. So these are all participate in the election of president. So first the elected members of both houses of parliament. Here both houses means there is Lok Sabha and Rajya Sabha. The elected member of legislative assemblies of the states, then the elected members of the legislative assemblies of the union territories, only the Delhi and Puducherry. So however there is also a nominated member in both houses of the parliament, but the nominated member of both houses of parliament and the nominated member of state legislature did not participate in the election of the president. Even the nominated members of the legislative assembly of Delhi and Puducherry do not participate. So suppose when assembly is dissolved, there is a criteria. When assembly is dissolved, the member is ceased to be qualified to vote in the presidential election. Means suppose an assembly is dissolved before 5-year term. So and at that situation, the members of the assembly cannot participate in the election of the president. So even if fresh election to the dissolved assembly are not held before the presidential election. So now we'll look at what criteria did a president is elected. So the constitution constitution provides there should be the uniformity in the scale of representation of different state, as well as the even the both houses of the members. So now we'll see the on which manner a president is elected. Now the first criteria is every elected member of the legislative assembly of a state shall have as many votes as their multiple of 1000 in the quotient obtained by dividing the population of the by the total number of elected member of assembly. That means for securing the uniformity in the scale of representation of all state, the constitution provides that the value of vote of one MLA of each state, means the value of vote of an MLA of each state is to be the proportional to the proportional of that state. Means so this is MLA. So how we will decide what is the value of vote of an MLA? That is the total population of state divided by the total number of elected members in the assembly. Total number of elected member, that is MLA, and in the which is multiple of 1 by 100. So now we'll see the second criteria. Every elected member of either house of parliament shall have such number of votes as many obtained by the dividing the total number of votes assigned to the member of legislative assemblies of the state by the total number of elected members of both the houses of parliament. This can be expressed as, now we'll see what is the value of vote of an MP, who is a suppose the vote of MP. So how will calculate the vote of MP? That is the earlier the first criteria we see the total value of votes of all the MLAs of all the state. That value, the first criteria value is divided by the total number of elected members of parliament. So the president, so we will see the two criteria, that is the vote of an one MLA and the vote of an MP. So the president election is held according to the system of, so it should be done on the basis of proportional representation by means of a single transferable vote, and the vote shall be held in a secret ballot, not like in open ballot. So this system assures the successful candidate is written by the absolute majority of vote. So a candidate, in order to declare elected to the office of president, he must secure a fixed quota of vote. So means to 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 win an election, the the nominated member should get the absolute majority of vote, and he in order to declare elected to the office, he should secure fixed quota of vote. The quota of, now we'll see how the quota of vote is determined. The quota of votes determined by dividing the total number of valid vote pooled by the members of candidate to be elected, plus, that is here is only one candidate, and plus 1, and adding 1 to the quotient. The formula can be expressed as like this. Now we will see the electoral quota. So suppose this is the electoral quota. So earlier we see the two criteria, that is number of a vote of an MLA and the number of a vote of an MP. So that two result will put in the first, that is total number of valid vote pools by the suppose so here is one means one candidate is contesting. If we see like 5 candidates is contesting for the office of president, like then it will be the 5 plus 1. See here is given that in bracket is given that here only one candidate to be elected as the president plus 1. So this is the plus 1. So adding to, so the quotient, so whole quotient is should be adding to 1. So to quotient, therefore suppose each member of the electoral, now we'll see how he will get the maximum vote, like how decide the which candidate win the. So each member of the electoral college is given one ballot paper. The voter, while casting his vote, is required to indicate his preferences by making 1, 2, 3, 4, etc. against the name of candidate. This means that the voter can indicate as many preferences as the candidate in the fray. Suppose here contesting. Suppose here is contesting 5 candidates. So suppose A, B, C, D, E. Now Now, while casting vote, the those who vote in the ballot, they will make preferences, like he will be give them the first preference, might be C is given the first preference, or might A given the second preference, or E given by the second preference, or might be like mm, B given the first preference, D given the second preference, like that. So so got it now. So in the first phase, the first preference is like A got the first preference, or C got the first preference, or B got the first, or E D, anyone who is got the first preference. First 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 counting will be, first count the first preference, who were given the first preference vote are counted. In case candidate secured the required quota, suppose in the first phase, candidate got the required quota, he or she should be the declared elected. Otherwise, the process of transfer of vote set in motion. The ballot of candidate securing the least number of the first preference voter cancelled, and his second preference voter transferred to his first preference vote of other candidate. Suppose by any chance, so suppose by any chance A got least preferences, least preferences. So this will be rejected. Suppose I'm clearing that. Suppose A, B, C, D, E. By any chance, suppose A get least preferences. So and so A will be rejected. Now B, it will transfer to A where it get the first preferences. Sorry, it will be B who will get the first preferences. So all doubts, suppose there is a doubt and dispute in the connection of the election of president, it only and only should be decided by the Supreme Court, and whose decision is final. So the election of election of person as a president cannot be challenged on the ground that the electoral quota was incomplete. So if election of is declared void by the Supreme Court, or acts done by him before the date of such declaration of Supreme Court are not invalidated and continue to remain in force. Suppose a candidate declared win. Suppose he had done or she has done something wrong, or acts done before date of such declaration of Supreme Court, is that not continue to remain in force. However, definitely there is some criticism. So, however, Constitutional Assembly criticized the system of indirect election to the president as undemocratic and proposed idea of direct election. See, so however the Constitution, so some criticizers are demanding that as normal election like Lok Sabha or state assembly election, each president election should be held in direct method. Why choose the indirect method of election? So however, definitely the constitution maker chooses indirectly. Definitely there should be the some reason. Now we'll see the why constitution makers chooses the indirect election for the office of president. So the indirect election of president is in harmony with the parliamentary system of government envisages in the constitution. Under this, presidency is only a nominal head executive, and real power vested in the council of ministers headed by the prime minister. It would have been anomalous to have president elected directly by the people and not given him any real power. The direct election of president would have been very costly and time and energy consuming due to vast size of the electorate. This is unwarranted, keeping in view that he is only a symbolic. See, we have seen that he is the nominal head, where prime minister is he is the head of the government. So the president is the nominal head. Even even uh, even like the real powers are actually vested in council of minister, which is headed by the prime minister. He just based on the advice and aid and advice of the council of minister, which is headed by the president. So And if suppose such huge such huge see India has a very huge population. If we go for direct election, that will be huge costly for to conduct election, and even time and energy consuming, because see there is a very vast size of electorate. So some member of constitution suggest that the president should be elected by the members of two houses of parliament alone. The maker of constitution did not prefer this, as the parliament denominated by one political party would have invariably chosen a candidate from that party. Such president could not represent the state of in could not represent the state. The present system makes president as a representative of union and state equally. So further, it was pointed out that in Constitutional Assembly that the expression of proportional representation in case of presidential election is misnomer. The proportional representation takes place where two or more seats are to be filled. In case of president, the vacancy is only one, so it could be better called a preferential or alternative vote system. Similarly, the expression of single transferable vote objected on the ground that no voter has single vote, every voter has plural vote. See why there is why for president given the proportional representation by means of single transferable. See proportional representation in presidency is misnomer, which just means suppose there is a post of only one suppose president is one, so it is for one candidate, might be many, but the post is for one. So that's why taken president should be on the basis of proportional representation. And why it's single transferable? But because the see the earlier we see that ML value of MLA vote, value of MP vote, so which is represented by the by large number of population. That's why this taken the single transferable vote. So now we'll see the qualification and oath and condition of the, so which is covered by the article 58. So before entering into the office of president, he should fulfill the following qualification before entering into the office. So what are the first condition? He should be the citizen of India, and he should complete the 35 year of age, or he should be qualified for the election as a member of Lok Sabha, and he definitely, and the what is the fourth criteria? He should not hold any office of profit under the union government or any state government or any local authority or any other public authority. So as sitting president or vice president of an union, the government of any state, and a minister of union or any deemed to be hold office of profit, hence qualified as a presidential candidate. So there is a fourth criteria given on the basis of which a president is elected. He should be the first citizen of India. He should completed 35 years of age. He should qualified for the election of the member of Lok Sabha, or and definitely he should not hold any office of profit under the government or any other state or any local authority or public authority. So before giving a nomination to the election commissioner of India, so he had to put a before election he should or she should have to be given nomination letter to the election officers of India. So while and that nomination should be subscribed by at least 50 electorate as a proposer and 50 as a seconder. So every candidate make a security deposit of 15,000 in the Reserve Bank of India. That is, here to deposit 15,000 in the Reserve Bank of India. The security deposit is liable to be fortified in case of candidate fails to secure 1/6 of the vote polls. So is the new criteria. And before 1997 there was another criteria proposed in 710 each, and amount of security was 2500, and in 1997 this discouraged the non-serious candidates. So suppose suppose president is president qualified the 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 four criteria, and he is elected, and he is on the election. So now the candidate, before entering into the office of profit, he should be he should he should be he should take oath and affirmation. So before which is covered under article 60. So before so now how president make and subscribe the oath. In his oath, president swears to faithfully execute the office, to preserve, protect, and defend the constitution and the law, to devote himself to the service and well-being of the people of India. So there are three kinds which he has to subscribe before entering to the office of president. Who in the while taking he should take oath. By that he will faithfully execute the office, preserve, protect, and defend the constitution and the law, and to devote himself to the service and well-being of the people of India. So now we'll see the election. So see in this box different president who is elected throughout the year, like 1952, 1957, 1962, 1967, 1969, 1974. So the first president was Dr. Rajendra Prasad, who secured 50, which is not required to even memorize it. Just look who are all our past president and just skip that. So now so definitely he had to subscribe and makes oath. So now who administered that oath? That administered oath is by Chief Justice of India, and in suppose Chief Justice CJI is absent, then in terms he is administered by the senior most judge of Supreme Court who is available. So any other person acting as a president or discharging the function or the president undertake the similar oath and affirmation. So now we'll discuss about the condition of president office, which is given under article 59. So what now we'll see the condition of president office. So what constitution given the condition to the president office. So suppose so the condition are that he should not be a member of either house of parliament or house of state. Suppose if any such person is elected as a president, he is deemed to have vacated his seat in that house on the date on which he enters upon the president of office, or he should not hold any office of profit, or he is entitled without payment of rent in use of his official residence, that is Rashtrapati Bhavan, which is in Delhi. He is entitled to such emoluments, allowance, and privileges as may be determined by the parliament. The emoluments and allowances cannot be diminished during his term of office. So the constitution given that suppose he should not be a member of parliament or house of like Lok Sabha or even a state legislative assembly. Suppose he is elected president. So elected as president, now he's so now it will be thought like he's vacated his seat on the past like in member the seat of parliament or the seat of state, so on the date on which he is entered the office. So, and he should not hold any office like office of profit, and he is entitled without any payment of rent and to use of the official residence, that is Rashtrapati Bhavan, and he should be entitled to such emoluments and allowance. So that will be decided by the parliament, and he cannot be diminished into such that his emoluments and allowance can be diminished during his term of office. So now we'll see in 2008 in 2018 parliament increased the salary of president from 1.50 lakh to 5 lakh per month which is in earlier this 2008 it was like 3 lakh per annum, um, which is 50% of his salary per month. In addition to the former president are entitled to even pension, furnished residence, phone facilities, car, medical, travel, and secretary staff office expense up to 1 lakh per annum. The spouse of deceased president is also entitled to family pension, at least at the rate of 50% of pension of a retired president. For the president is entitled to number of privileges and immunities. He enjoys some personal immunities from the legal liability of his office acts. During his term of office, he is immune from any other criminal proceeding. Even in respect of personal act, he cannot be arrested or imprisoned. However, after giving 2 month notice, a civil proceeding can be instituted against him during the term of office in respect of personal act. Suppose he is done something personally, crime or like anything who is done personally, so at that time he gets some immunity like personal immunity from any legal proceeding or anything. But in case of like personal act, he, he can be prosecuted only after giving 2 month notice prior the proceeding can be prior the proceeding. So now we'll see the term, impeachment and vacancy. So what is the term of office, which is covered under article 56? So article 56 given about the term of office. So normally president hold office for term of 5 years from the date on which he enters upon the office. However, he can resign from his office at any number of time by addressing the resignation to the vice president. Further, he can also be removed from the office before completion of his term by the process of impeachment. The president can hold office beyond his term of until the next successor assume charge. He also eligible for re-election to that office. He may be elected for any numbers of time. However, in USA, a person cannot be elected to the office more than twice. So, what is the term? So, Article 56 of the Constitution given the term which tells about the term of office, which is so president office is just 5 years from the date on suppose he is entered on the 5 5 January 2022. Then here and then here to the term will be like that from 5 January to 22 to the next 5 year. So even before the completion of his term, he even can resign. He can resign. That resign letter should be given to the vice president, or he can be removed by the impeachment, or president could suppose the next successor is not yet elected, so he can hold office beyond his term of 5 years. Like the next successor assume charges, even his office, even that candidate can re-elected to that office any numbers of time. However, in USA that is only for 2 times. So next is impeachment. How president is impeached? Like Article 61 define about the impeachment of president. So the president can be removed from his office by the process of impeachment for violation of the Constitution. However, Constitution does not define meaning about the phrase violation of Constitution. So a president can be impeached only after the violation of the Constitution, but the Constitution yet does not define that what does mean by the violation of the Constitution. However, the impeachment charge can be initiated by the either house of the parliament, and these charges should be signed by 1/4 member of the house that the frame charges, and 14 days notice should be given to the president. After the impeachment resolution is passed by a majority of 2/3 of the total membership of that house, it is sent to the other house, which should be investigate charges, and the president has the right to appear to be represented at such investigation. If other house also sustains the charges and passes the impeachment resolution, by majority of two-thirds of the total membership, then the president stand removed from his office from the date on which the resolution is so passed. Suppose the members of like the members of Rajya Sabha or even the members of um, Lok Sabha can initiate the impeachment charges. So the impeachment charges that should be signed by the fourth member of that houses where the where the impeachment charges are framed, and a 14 days notice even should be given to the president prior charges. So after impeachment resolution, so that resolution should be the passed by the majority of two-third member of the that house that is present and voting. And after passing, suppose two-third majority has given had signed, and next it should be transferred to the next house. Even the charges are initiated. Suppose the charges suppose charge initiated in Lok Sabha after passing by one-fourth mem suppose after passing by two-third member of the that house, then it deemed to be passed by the first house, then it should be the sent to the second house, that is Rajya Sabha. So they will investigate. However, during such charges, the president is appear and represented at such meeting, has the right to appear and represent at such meeting. Suppose if other house also declare that the charges and passes of is charges, suppose approve the charges and passed. Suppose now the Rajya Sabha approved the charges, approved that charges. Now which approved the charges. Now it has been passed by the two-thirds of the total membership of present and voting. Now president stand removed from his office from that day on which the resolution is so passed. Suppose it is passed on the 2 January 2020 passed, then he should be removed from his office from that day on which, that is 2 January 2022, on which the charge is initiated. However, impeachment is a quasi-judicial procedure in the parliament. In the constitution, two things should be noted: that the nominated member of either houses of parliament can participate in the impeachment procedure, though do not participate in his election. The elected members of the legislative assemblies of state and union territories of Delhi and Puducherry do not participate in the impeachment of the president, though they participate in his election. So earlier I tell that during the election of president, where all the members of Lok Sabha, all the members of Rajya Sabha, all the members of state legislative assembly, all the members of UTs, that is union territories, in case of Delhi and Puducherry, all participate in the election of president, but not the nominated member of any of the houses participated in the election of the president. However, during impeachment, the nominated member of both houses, that is Lok Sabha, both houses of parliament, that is Lok Sabha, Rajya Sabha, participated, but nominated member not participated in the election of president. And here also one of the obligation is that the during the election of president, all the members state legislative assemblies, even the UTs, in case of state and in case of Delhi and Puducherry participate, but in case of impeachment they do not participate. So it can be like that controversial, like it's not fair. So now and talk about the vacancy of president office. There is a vacancy. Suppose president is vacant his office. Now vacancy of office is covered under article 62 of the constitution. So a vacancy in the president office can occur in any of the following cases: like on expiry of his tenure of 5 years, on his resignation, on his removal, by the process of impeachment on his death, or otherwise when he becomes disqualified to hold office, or when his election is declared void. So when we say the president office is vacant, the president of office of the office of president is vacant during, suppose his tenure of 5 years is done or completed his 5 year, suppose he is resigned by resigning by letter to the vice president, or by removal by impeachment, or by his death, or his election is disqualified, or his, so on that case the president of, suppose when, then what will happen if president office is vacant? So it does not mean that the office of president is vacant, there is a elected president. So the the vacancy is going to be caused by the expiration of term of sitting president, and election to fill must be held before the expiration of term. In case of any delay in conducting new president, the outgoing president continues to hold office, so until his successor resumes. This provided by the constitution in order to prevent an interregnum. In this situation, the vice president does not get opportunity to act as a president or to discharge the function. If the office fails by resignation, removal, death, in that case, filled by the occurrence, the newly elected president remains in office for full time of 5 years from the date he assumed the charges of office. When a vacancy occurs in the president due to his resignation, removal, or vice president acts as a until further when sitting president is unable to discharge in illness or any vice president discharge his president resume his office. Okay, suppose suppose his suppose suppose his term is expired, like 5 year completed. So in that case, not vice president will acted as a president. In that case, the earlier president should be continue his term of office until the new president is elected. So, and suppose if president office is vacated by the removal, death, or otherwise the um, or by removal or resignation or death, in that case election of president should be done in 6 months. At that time vice president is acted as a president. Suppose vice president is also not there, so in that case chief justice of India acted as a president or discharged the function of president. So when any person, that is vice president, chief justice, or India senior most acting as a president or discharging the function of president, he enjoys all the powers and immunity of the president, is entitled to such amendment and privileges as are determined by the president. So suppose I said I told about that suppose if the expiration of if president term is expired, at that case earlier president would continue his term of office until the next president assume the office. Or if in case of expiration, if in case of like death, or like resignation, in that case vice president will act it. If vice president also not present, in that case chief justice of India will act as a president. During, suppose like now vice president or chief justice of India, that is CGI, is also acted president, and and they will enjoy all the power and immunities of the president, and there should be the that annulments and allowances and privileges as president got. So we have discussed until this what we have discussed. Just a quick recap. We have talked about the article 52 to 78 of 5 talk about union executive. Now who are union? That is vice president, prime minister, council of minister, attorney general. So basically he is the nominal nature, he is the first citizen, even he is the head of the Indian state. So then article 54, election of president. Then article and how and on which manner the election is conducted of for the office of president. And Now here we have discussed about how a candidate is declared declared win, or like as a president. Suppose, and then we have talked about qualification and oath and condition. President, what qualification a candidate need to become a president? Then suppose if elected, now before going into office of he need to subscribe or make oath affirmation. Article 68 of the constitution defines that. Then we have talk about the condition of president. Article 15 of the constitution define the condition, like on on what basis. mm, then we talk about the salaries of president. And about talk about the immunity, what kind of immunity he get while in office of president. Then we have talked about term of office, like article 56 of the constitution define about the term of office. Then impeachment of president, what about the impeachment, like how is removed from office. Then we have talk about article 60, which talk about the vacancy of president. If president office is vacant, then who will act as a president. So that's all about today. So the next topic we are going to discuss about the power and function of the president in the next upcoming classes. So if you have any kind of doubt, please put a comment on that. I will try to discuss it in the next class.